Well, here I am in Abercrombie Square on this beautiful day, smelling the roses and generally topping up my tan. Only joking, I'm here to talk to you about Tribe and Tribe, which is, in terms of citation, 1995 for All England 236 in terms of the citation. It's an incredibly interesting case. I hasten to add that the protagonists, Kim Tribe, the son, and David Tribe, the father, are not relatives of mine. I'm unrelated to them. And that's interesting or important because, of course, there was illegal activity going on. It's, of course, a resulting trusts case, or more accurately, a presumption of advancement case. And the facts are these. Essentially, David Tribe was a businessman who ran a number of shops. He rented the premises. He had to repair some of the premises pursuant to the schedule of dilapidations in his lease. He couldn't afford to do so, so he was a bit worried about his illiquidity. So he transferred the shares to his son, Kim Lawrence Tribe, and then, in essence, attempted a transaction in fraud of creditors, which of course is illegal. So when he subsequently asked his son to transfer the shares back, the son refused and said no, because the son knew his equity. He said, no, the presumption of advancement means that that was a gift to me, I don't have to return those shares. David Tribe's obviously vexed at this. He attempts to use that illegal conduct, or potentially illegal conduct, as evidence which he adduced to try and rebut that presumption of advancement. But of course, what happened in terms of facts was that illegal activity never actually occurred. So David never actually transacted in fraud of his creditors. Meaning then, therefore, that he was able to adduce that nefarious activity, leading to a rebuttal of the presumption of advancement, meaning that those shares should be transferred back to him from his son, where prima facie, of course, we think that those shares may now vest in the son as a gift because they were passed as property from the father to the son. So that's Tribe and Tribe here from the sunny environment of Abercrombie Square. Do enjoy the case. Think about it in relation to Tinsley and Milligan as well, and that case, and the presumption of advancement generally, and how we might think the presumption in the modern context is perhaps outmoded. So I must get back to the roses, and on that point I bid you goodbye. So goodbye. Okay, so here is our next case in our run of cases on the presumption of advancement, and in particular this case is one which builds on the judgment that we've seen previously in Tinsley and Milligan on illegality and the presumption of advancement. So this case, of course, is dear to me because of the name, not, though I hasten to add, because I'm related to any of the protagonists. So as you can see, it's Tribe and Tribe, and our citation is 1995, square brackets, Chancery at 107, because as you can see from the panel of judges, it's in the Court of Appeal, with Norse Millet, as he then was, subsequently of course Lord Millet, famous Chancery barrister, then judge, then Otten on the panel. So then we go through to our catchwords here, which I've highlighted for you, which give us a very brief synopsis of what was going on, what was being discussed before the Court of Appeal. We have the father voluntarily transferring shares to his son for no consideration for the purposes of deceiving his creditors. So we know about the presumption of a resulting trust. We know about the presumption of advancement, that's to say a presumption that rebuts the presumption of a resulting trust. And this case is of course interesting, as we see as we go down through the catchwords and into the body text, Because what we have here, in terms of facts, is a father attempting to deceive creditors, which, as we're told, is illegal, because of breaches or potential breaches of covenants to repair in relation to these schedules of dilapidation. So a company has as its object selling ladies' clothing from a number of shops. These are rented. As you can see, one of the 4 children, a son of David tribe, is given shares so as to hopefully protect his assets, because of course the father couldn't afford to service these schedules. However, whilst those shares are transferred in due course, no repairs are affected, as you can see. So in the event no repairs were carried out, but the father, of course, wants his shares back. So thereafter, the plaintiff requested that the defendant to transfer the 459 shares in the company. Of course, the son refuses, and this is the interesting, stroke amusing point. The father, David Tribe, is up to shenanigans, of course. If you're a creditor anyway, you might think that. Whereas Lawrence Tribe, the son, is just saying, no, look, he knows his equity. He's relying on that presumption of advancement. Of course, it's absolutely fine, in his view, for him to keep those shares. Indeed, it's the very operation, that presumed gift, that arises from the presumption of advancement. And prima facie, of course, we'd say that, well, the father, David, is on a sticky wicket, because, of course, how can it be the case that he can rely on illegal evidence or reduce evidence of illegality to help rebut that presumption of advancement? Because, of course, if we're coming to equity with clean hands in terms of maxim use and thinking about Tinsley and Milligan, we know that one must approach this equitable jurisdiction with clean hands. However, as we can see, since the transfer, so this is the held section of the head note, since the transfer of the shares was a voluntary transfer between father and son for no consideration, the presumption of advancement applied unless the transferor could rebut it, namely David Tribe, which is important because, as we'll see over onto the next page, the plaintiff had been entitled to lead evidence of the agreement with the defendant in order to rebut that presumption. In other words, the presumption of advancement did kick in despite the potential to illegality of this activity, because, of course, the activity was never carried out, as we've seen higher up in the catchwords, just here. So when you're looking at the case, obviously you will descend below the head note, as I've done, but as you can see, it's a fairly weighty judgment. There are the cases cited in argument. There are the key protagonists, David, the father, then the son, Kim, Lawrence Tribe, legal purpose, or reference to Tinsley and Milligan, previous activity. Going through counsel's argument there fairly rapidly, then bang, straight into the judgments, the 3 judgments of the Court of Appeal, after they'd taken time for consideration with the cur ad volt there. Norse, where he outlines the question before the court. Here the question is whether the presumption of advancement applies, the transferor can still recover the property on the ground that, although he is forced to rely on the illegality in order to rebut the presumption, the illegal purpose has not been carried into effect. And of course, you'll descend through the rest of the judgments and the authorities that are cited therein to see what the judge says and how he gets to his conclusion. And the conclusion I've highlighted for you, or the salient part of the conclusion, is here, of course, where we're thinking about the outcome in this case. So, as I've said, the activity wasn't carried out. The father can adduce that evidence, and then therefore he's able to rebut the presumption of advancement. Then, of course, Millet and Otten follow. So descend into these judgments, have a look at them, mull on tribe and tribe, see how it fits within the overall scheme of the presumption of advancement and adducing evidence to rebut that presumption. On that note, then, I will bid you goodbye. Goodbye.